we are. Thank you very much for joining this OxFirst webinar just before Christmas. We are talking today about the role of patent pools and the business model of patent pools and the opportunities and limitations associated with aggregating patents and teaming up with other companies to license intellectual property. For those who don't know OxFirst, OxFirst has been founded over a decade ago by academics of the University of Oxford, namely myself and some other fellow. And we were keen on bringing the practice of IP management, the practice of business of intellectual property closer to the market. That was very much what our research was about. And we thought that that type of thinking about the economics of IP could have some interest in the real world. And the 10 years we have, over 10 years that we have been doing this has proven us right, that clearly people are interested in understanding better how to develop business around intellectual property and how to better understand how to manage IP from an economic paradigm. As part of what we do, we run a webinar series also now, gosh, for 10.5 years. We enjoyed it very much. It's once a month, and the idea is really to just have interesting conversations around IP and to get a grasp of what current trends are, to give new food for thought and to give new ideas and new perspectives on the practice of IP. Today we have two great speakers, and I feel very privileged that they have agreed to give a presentation today or to give they offer their insights. We have John Sideris, who is Principal Licensing Counsel at Philips. He can look at over 3 decades. He can look back at 3 decades of experience in the practice of licensing IP, and he really knows patent pools very well. And he has worked, I think, with most of the pools that are out there at the moment and has a good overview of what people do. He is joined by Thilman Mueller. Thilman is a partner with the German law firm Eisenfuhr and Speiser. Thilman equally brings a brilliant background in patent litigation to the table and is very experienced also in the legal aspects of IP management and the legal aspects of patent pools. When we started to think about what discussion to have around the webinar, we thought pools could be interesting because in one way there's a lot of talking around open innovation and about teaming up with others and sourcing from outside in information, providing from inside out ideas, and to understand really that the wisdom is in the crowd and in the community. The question is just how does this work together with IP, which basically does the exact opposite, is probably quite challenging, and possibly further insights into pools, into aggregators could provide some new perspectives on the topic. With that very brief introduction, I'd like to pass on the floor to John and Thilman to introduce themselves. And yeah, maybe already ask my very first question. So what makes a pool really? What is exciting about pools? John, why have you spent 3 decades of your career on IP pools and aggregating of all the things you can do in the world?
That's true. Yeah. Well, maybe I won't answer the personal part. We don't have enough time in 1 hour to do that. But thank you for that introduction, Roya. It's an honor to be on the panel, and I enjoy the opportunity to also address the audience on that. I'll just give a very brief background in addition to what Roya said. So I'm a US patent attorney. I have just over 30 years of experience practicing in the field of IP matters, covering all aspects from patent prosecution to contract negotiations, to M&A acquisitions of companies vis-a-vis the IP aspects, to licensing in and licensing out portfolios. And lately, my focus within Philips has been to manage the patent pools that Philips is involved in, but also to speak about FRAND issues and some of the legal issues surrounding the licensing of S&Ps, and to basically advocate for the positions in which there's a balance between the interests of the implementers, but also the interests of the innovators to get a return on investment in their patents. That's kind of what brings me to patent pools. I don't know, Thilman, do you want to just do a brief introduction of yourself before I start getting into the focus of this webinar?
Yes, sure. I promise to make it short. Also very glad to be here, and Roya, thank you very much for the brief the kind introduction. Yes, I'm working not as long as John, but now also for quite some years on IP matters, and been closely working with John also, and in particular on pool and the legal sides, obviously, since I'm a lawyer of pool licensing. So to touch upon your question, what brought me here, it was a good part. It was John actually, who brought these topics and this work to my table. Aside from that, I've also been involved in setting up standardization organizations, none of the huge ones that everybody knows, but more smaller ones. Nonetheless, a very interesting experience to design such a process from the beginning. And also we worked on setting up one or the other pool or joint licensing program, though my focus in particular in the last 10 to 5 years is really on IP enforcement and litigation. But so I'm glad that I had the opportunity to see really from the standard setting process to creation of licensing programs, joint licensing programs, to then, so to say, the end or the ultimate means of enforcement. But please, John, thanks for the opportunity to introduce myself, but please go on.
Yeah, it's good context for the audience to understand, from which basis we speak of experience. So also what I want to just talk about is just quickly what is a patent pool, just for the background, and for completeness, in case there are members in the audience who are not that familiar with what a patent pool is. Patent pool is a grouping of patent owners who, rather than licensing their patents bilaterally in a one-to-one negotiation with different implementers, they get together and agree to pool their patents, put them all together in one portfolio so that there's one license offering to the market of implementers. This is usually managed by an outside licensing agent, but sometimes it can also be managed by one of the patent owners. The patents that are put into the pool are typically focused to a specific standardized technology. And this is done for reasons of antitrust concerns, which my colleague Thilman will speak about just after I finish my introduction. What is done is that the focus is to license patents that implement a particular standardized technology, but not just any patents. These patents must be standard essential. And to be deemed standard essential, the pool uses independent evaluators to evaluate the patents so that only what ends up being licensed in the offering are standard essential patents. The evaluators are usually professionally licensed patent attorneys in different jurisdictions in which the patent essentiality is determined. For example, to determine if a European patent is standard essential, the European patent attorney will do the analysis and make that determination. Likewise, a US attorney will analyze the US patents and so on. So these patents are then all combined into one license agreement offering, usually a standardized license agreement so that the terms are non-discriminatory. So what is the benefit of this? The benefit is efficiencies. Having one bundle of patents that has already been vetted as necessary to an implementer's use of that standardized technology gives confidence on the licensee implementer side that they are licensing only the patents they need to license. On the other side of it, the patent owners have the efficiency of not having to individually license their portfolios bilaterally to the multiples of implementers. And I can give you some exemplary numbers. If you take the AVC MPEG H.264 technology, there is a patent pool for this, which has more than 35 different patent owners and more than 1,000 licensees. So of course, you can imagine if each of the 35 plus patent owners had to do an individual license negotiation with each of the 1,000 or more licensees, it would take an enormous amount of resources and time. So the efficiency of the pool is obvious, and that's what brings parties interested into the formation of the pool. Beyond that, there is some legal frameworks that have to be adhered to, antitrust and others. And for that point, Thilman, I would like to turn the floor to you to discuss some of the legal frameworks around the forming of the pool.
Yeah, thanks, John. And indeed, from a legal perspective, if you look at it from the outset, you can expect some legal skepticism towards pools, because ultimately companies get together and agree on a price. I mean, imagine automotive companies getting together and saying, okay, all our cars, we agree these and those prices on. You can imagine what the commission would think about that. And that is indeed why pools, when they came into existence more than 100 years ago for non-standardized technologies, were met with a great deal of skepticism, also because there have been occurrences where at those times pools were more like a non-assert club. So every member of the pool, which was not even publicly known, committed to not assert certain patents against other pool members, kind of a secret pool between certain companies. So these are the origins which were not met with much favor of the competition law authorities. This has changed, and actually changed a long time ago. Even I think in the beginning of the 20th century, there have been pools that were endorsed for aeroplanes and things like that. And in particular now, the pool development has gained traction with the standardization of technologies that John touched upon, which came about with basically this digital revolution, telecommunications, and all the compatibility requirements that go along with that. And obviously also antitrust authorities have realized that the patent pools are, because of their efficiencies, a way to cut through this patent thicket, as it's often called, and allow implementers as well as patent owners to reach a relatively easy and efficient agreement on the use of their patents. And so today there's no big discussion that a pool as such is admissible and does not raise as such antitrust concerns if certain guidelines that the anti-competition law authorities have put forth in the US, in Germany, but also in Japan are met.
Okay. So what really are the key factors that go into a pool? What makes or breaks the success of a pool? What's your experience?
Sure, I can speak to that. I'll start by talking about what are the factors that go into creating a pool today, to forming a pool, and then the success factors. So I'll speak about that separately. But so first, you have to start off with licensees who have patents in the field of this standardized technology, which is the focus of the pool. and that they are willing to get together and bundle their patents into this one offering. Once you gather the relevant parties together, one of the early things to determine is what is the scope of the technology to be licensed, meaning what will the licensed product be? Will it be just hardware devices that implement the technology? Will it also be services that take benefit of the technology? Will it be content? If it's, for example, a video or audio codec pool, content that is encoded and decoded using the technologies. So when that licensed product scope, after some deliberation, gets distilled down into what a consensus of the patent owners can agree to, then the next step usually is determining what's a reasonable royalty rate. And that involves some discussion and analysis as to what the contribution is of that technology to the end product, what value it brings to the product, but also what contributions were made to the standardization of the technology. And is it a big leap forward? Is it just an evolutionary increment, and so forth? In order to come up with what they think the market rates are, not only that reflect a proper return on investment to the patent owners, but also to a rate that the market is likely to accept without much enforcement needed and much dispute. So the royalty rate gets determined, and then the next step is, well, how to share the revenues that come in. And those are done through several types of arrangements that I will discuss later in the webinar. But basically that step is done. That takes a lot of time usually because as you can imagine, each patent owner is angling for a structure that benefits its patents the most. And then one of the final issues to be covered is enforcement. What will be the policy of the pool with regard to enforcing against unwilling licensees? And what will the funding be? Enforcement, well, that's a topic, Thilman, I think you can speak in more detail to. So I'll turn the floor to you on that point.
Yeah, thanks, John. Maybe half a step back before we come to enforcement. There are obviously a lot of legal considerations also that come into play. Once you set up a pool, you make these arrangements between the patent owners. I can be fairly brief here. The EU Commission has commented on that in their technology transfer guidelines, and there are similar guidelines in the US. In the US, you can actually also get business review letters. Certain pools have received such letters recently. For example, Avanci was issued such a letter some time back, and I think beginning of 21, another new pool has been issued such a letter. So which are basically a letter of comfort, which state that as of today, the pool doesn't meet any antitrust concerns in the US. Unfortunately, this is no longer the case in Europe, where the Commission used to proceed similarly, but has turned the system around in the early years of 2000 because it became too cumbersome for them, which is, I think, regrettable, and maybe something later when we look at the developing framework we could come back to, because I think these letters of comfort are quite important to provide the market and licensors and licensees with some confidence and a solid ground to say, okay, this pool has been reviewed, and as such, it's found to be in line with the antitrust laws, and then there may be still some issues to discuss. But it would take probably a lot of the problems away, which are, as you said, John, often discussed in litigation, because simply because you have a pool doesn't mean that everybody will be happy to take a license. To the contrary, I think at some point in the early stages of each pool, you will come to a point where you find that licensees are no longer willing to sign up voluntarily and want to test the resolution of the pool, also maybe confirm the royalty rates. And this is when it typically goes into litigation. Such pool litigation campaigns are somewhat more complex in handling and organizing than bilateral litigations. If you are an individual company going to enforce your patents, which is cumbersome enough, and I don't think any company in the world enjoys litigation. But when you go into a pool litigation campaign, you typically have multiple plaintiffs, different plaintiffs, licensors from the pool. You have the pool administrator to a certain extent involved, which means that you have to coordinate a lot of parties, a lot of agreement on the procedural steps and tactics. Then again, certain information must not be shared between, in particular, the licensors on pricing and so on and so forth. So it adds quite a level of complexity in handling such litigations. Though if you look on the side of what are the legal remedies, these are obviously not different. The court will recognize that this is a pool campaign, but it will assess each case patent by patent, and the legal remedies are then the same. So obviously you have claims for damages, rendering of accounts in Germany, but often also, of course, the pools and the licensors have to go for injunctive relief to either stop the use of their patent without a license, or bringing the licensor to the negotiation table. So I believe, and from my experience, no pool will on the long term be successful without litigation, which can be quite a hurdle. But then as the pool matures, also this, I think, wears off, because the pool has a reputation. It becomes more and more accepted, and it finds it easier to bring licensees to the table.
Talking about reputation, do you, from your experience, think anyone can just start a pool? Can just any startup say I'm becoming a pool now? Or is this more reserved to a bunch of insiders?
No. So let me answer that. So, in order to start a pool that is successful, of course, literally anyone can say, here, we are 2 patent owners and we put our patents together in a pool and offer it to the market. But really what makes a patent pool successful, based on the current environment that licensing operates in, is one, you have to have a critical mass of the patents. And that's not a numerical number, but just a large enough number of the patents that are licensed, that are being actively licensed out of the total stack of patents that exist covering a particular technology. That critical mass should be in the patent pool. That makes it attractive for licensors, because they find that they have this one-stop shop to go to and resolve a lot of the patents that are out there that they know that they will need to take a license to. So it's that critical mass that's one of the main factors. A second factor is also an acceptance of the royalty rates by both the implementers that have to pay it, but also the patent owners that are licensing their patents. And what I mean is that if a pool is formed in which the rates are too low for the market of patent owners to accept, they don't join the pool. And then you don't get that critical mass of patents. They either stay out of the pool and try to obtain valuation through bilateral licensing, or like in the case of HEVC licensing space, they form their own separate pool. And this occurred not just once, but twice in the HEVC space. You had ended up with the first pool being formed that had good support from the implementer side, but not enough support from the patent owner side. And some of the patent owners then moved over, formed another pool. And even that pool didn't satisfy some patent owners in terms of what they thought would be a good valuation for their portfolio. So they either stayed out or they went and formed a third pool. And this, because now you didn't have this market acceptance of what the proper rates should be on either side of the coin here, you ended up with three pools, which caused a lot of confusion in the marketplace. It made licensors, implementers hesitant as to what pool to join, what would be deemed FRAND, which pool would survive if there's going to be some consolidation. And that delayed a lot of the market acceptance of the pooling there. So it was a big factor against the success of HEVC, in that there wasn't this good balance between the implementer interests and the return on investment of the patent owners. And then the third factor is what Thilman already spoke about, enforcement. I think you heard a lot that it's necessary. I give one example. There was a patent platform, kind of a pool, formed called IPXI, but they wrote in their mission that they would not enforce their patents. So they went on the belief that companies using the technology would respect the IP of others and come and voluntarily take licenses. Well, it collapsed, and in their statement as to why they were closing down, it was because they were not allowed to enforce as per their bylaws or mission statement. So the enforcement is important, and that's where what Thilman spoke about. It's the necessary third factor for success of the pool.
IPXI, I was involved in IPXI.
Okay.
It may have been ahead of its time. Its intention was never to be a pool and to enforce intellectual property against others. Its intention was to create some sort of stock market for IP trading. It was created by people who had a background in investment banking and finance originally. And they thought about it like, wow, you can trade hurricane and you can trade earthquakes. Why not start trading also intellectual property? This could be a massive opportunity to build your pension and around intellectual property, not just around buying an apartment that's your pension. So this was a whole different logic to it. But I had the impression there would have been too much awareness raising needed among the IP community, who has a different DNA and with no background in finance. And you would have basically retrained them and tell them, guys, finance law is just as exciting as intellectual property law, or just cater to a whole different audience. But it was maybe a cultural clash. It was not a pool in the classical sense. It was really an opportunity to trade unit license rights as an investment vehicle. And then from there, go and build a stock market and get the finance guys really excited about IP. And so it was a whole different thinking, which the market did not yet buy. I agree with you. They were thinking in catch me, fight me. They were in a different way of seeing the world.
Yeah, but I remember reading their statement when they shut down, that they said that unfortunately, because they didn't go through the use of an enforcement, that they felt that was one of the reasons that there wasn't interest in their business model. So that's an unfortunate truth. Enforcement is important not just for the patent owners, but it's also very important for the licensees that take the pool license, because they don't want to be at a competitive disadvantage where they respect the intellectual property, they compensate the intellectual property owners, but then their competitors don't. So they also want enforcement against unwilling licensees. It's not just the patent owners that have an obvious motivation for it, but it's also the licensees. They want the level playing field. And that is what ends up leading to the success of the patent pool, is that the licensees know, yes, okay, they must pay this royalty fees for their use of the technology, but their competitors are doing it also, so that they're all at the same place.
But John, do you see any interest in Thilman from the finance community? Are there any investors that want to put their money into pools and aggregators, or is this still basically tech corporations, and that's it, working detached from the finance community?
My experience has been the latter, that it's detached from the real interests of what's going on in licensing. Where I see it is just funding litigations where they think they're going to just get a return on money. But that's, fueling more contention. And that's one of the good things in pools is it's a less contentious environment to license patents in. So.
Yeah, I agree with you, John. The only cases I've been aware of where you have financial investors are either, as you mentioned, John, as financing certain litigation of people, patent owners who don't want to throw in the money, and then the investor obviously takes a share of what is the financial outcome. Or we have recently also seen capital market firms buying IP assets in order to then monetize them, but they actually buy the assets. So you have a venture capital company that owns certain patents for the sake of enforcement and acting as an NPE, basically. Okay. But in pools, I haven't seen that. I've never seen that actually. It is a bit my impression that at least today, as of today, that might change in the future. The pool community, so to say, and also the companies that license through pools is a fairly tight network. So if you go across all these licensing programs that you can find for example, on the webpage of MPEG-LA, and you maybe add via licensing and so on, you will see the licensors of these programs, they're reappearing names. Mm-hmm. And most of the names you will recognize from other contexts. They're known innovators, known patent owners, but I doubt that you would come across about any venture capital firm or so.
Interesting.
And Roya, on that point, in my own personal opinion, it's important that the revenue from patents goes back to the innovators that spawned the patents, not people who use them as investment vehicles. Because it's the innovators who get a return on their investment that will fund future investment in research and development and new technologies. So it's better, in my opinion, to keep that circle closed between the innovator, patent owner, and the implementer that benefits from the use of that technology to fund further research. Money that departs to go into the financial world, well, hard to say that comes back to benefit the ecosystem and the future evolutions of the technology.
Good point. Good point. Yeah. And a question I've been burning to ask you is the historical evolution. Over the decades, what have you seen have been the major changes?
In the patent pool environment?
Yes.
Well, what we've seen, so Thilman referred back to the history of patent pools going back over 100 years. That's correct. The modern patent pools pretty much started with the MPEG-2 video pool in 1997. It was enormously successful for the factors I mentioned, that they did get a critical mass of the patents. In fact, by one point, I believe they had all of the essential patents in the pool for that technology. The rates were accepted by both the implementers and the patent owners. And that success spawned additional pools. So what we saw is the success created many more spin-off pools. They have grown in numbers. They've expanded to address new technologies. We see that, in fact, even in the standardization and the standard setting environment, they recognize that the new version of a technology or a new technology will emerge soon, standardize soon, how to address the intellectual property issues that will come alongside it. And they support the formation of pools. They encourage it, like the DVB organization, for example. We know that the EU Commission also supports it. So what we are seeing is a growing interest in pools, not a diminishing interest. But having said that, some pools have been successful. A lot of them have not been successful for those reasons I mentioned, not getting enough interest of the critical mass of patents and support from the marketplace and enforcement.
So how do they get it right? How do they get it right in saying this is a rate which everyone can roughly live with? They go like the somehow they ask people, or how do you feel, how do you get that to
That's a good
point where
question.
everyone can say, okay, that's something we can.
Yeah, that's a good question you ask, because we didn't touch on that. In the formation of the pools, it's not just owners who are sitting during the formation and deliberating what should that royalty rate be? What is the value of the contribution to the product? It is often including implementers in the formation of the pool. And in fact, also many of the patent owners are implementers. So they have an interest in getting the balance between their return on investment and what they pay, getting that balance correct. Now, how to set that balance? Well, there's analyses that are done as to what the contribution value is from that technology in a product. And then, it's so dependent upon the technology and the marketplace. MPEG-2 video was, by today's perceptions, expensive. It was started off at $4 a unit. And you would say, wow, that's a lot of money to add. But MPEG-2 was a market transition in the marketplace. Video before that was all in an analog form. It was on the cassettes, the VHS and the unsuccessful Betamax. But once you digitized video, then you can have it on your PC. You can have it now on your smartphones, tablets, etc. It was a big leap forward. That changed the world a lot when it came to video distribution. That transition justified, the market accepted a higher price. When the next evolution of that technology emerged, AVC, the marketplace didn't see the same big leap forward. And so there, the marketplace settled on a 20 cents per unit royalty.
From $4 to 20 cents. That's huge.
It is huge. Now, let me just add for our audience. Let me just add for our audience, the $4 was lowered over time because it was, whatever, for market reasons. It lowered eventually down to $2 per unit, but the next pool was 20 cents a unit. But now, let's continue. After AVC was HEVC. The first HEVC pool came out of MPEG-LA. They also set the rate at 20 cents per unit. But that, maybe in hindsight, was not the right balance between what was needed to compensate the patent owners versus what the market of implementers wanted. And that's why you had patent owners that didn't join that pool and instead formed a second pool and then a third pool, in each case, I believe, more expensive. So tricky to do, and there's so many factors as to what goes into a reasonable price for.
So what about 5G? What would be your best guess? What would be a good rate for a 5G pool? $4.20, somewhere in between. Do you think it's a total game changer that justifies that, or is it more incremental? Or
well, what makes your question difficult, I would say, maybe out of context. There are few pools that have 3G, 4G patents. That industry tends to prefer bilateral licensing rather than pools. And the pools that have come out so far have been struggling because they don't get that critical mass of patents and the acceptance of the implementers. The implementers tend to like bilateral, maybe because they can negotiate better deals than they think they would get through the pool. So you're asking me what's the right 5G pool price? If yeah, hard to say because history has shown that pools have not been successful in this space. And in any case, it should be deliberated between all the stakeholders, patent owners and the implementers. So, yeah, what can I do to give you an answer for that? It needs a joint answer.
But I mean, if you just as an indication, if you sum up all the bilateral royalties which you have to pay in a 3G and 4G sphere, just to the major licensees, you would come up with maybe even two-digit dollar figure. So, you know, Qualcomm charges, I don't know, $5 a unit, and you know, there's a lot of bilateral licenses which are charging around $1 or in this range. If you add all this up, I think the royalty burden for 4G and 3G could be close or around $10, probably even more. So if you make the assumption you have a 5G pool that really, you know, includes a reasonable figure of a reasonable share of the complete patent landscape, you would easily come up with that space. So at least it wouldn't be 20 cents.
Well, what about the regulatory environment? Is that a success factor? I think it's more Thilman's question. Is there anything that can be done from a governance perspective, from a judicial perspective?
In terms of determining prices?
Not so much determining prices, no. I think that's an industry question. I tend to more think in order to, I'm not saying to incentivize pools, that's probably the wrong question, but more to incentivize some forms of efficiency of licensing transactions. Is there anything that could be done from a policy, legal perspective, or is it really up to the market to get the price right and to get the right team together and get your hands on the right patents and try to find a good compromise with everyone?
Yes, I think putting the pricing discussions on a legal level, that's the wrong place. And from my perspective, this is also the route that the European Court of Justice has gone with Huawei ZTE, and that is implemented at least by the German courts. As you may know, other than in the UK or the US or China, German courts have never determined a friend rate, but they say, and that's also what the European Court of Justice basically gave, they gave a framework of negotiations. So what they want to do is they want to give a legal guidance for these friend discussions, but and patent owner and licensee have to adhere to these legal framework and find a solution within itself. And very recently, Mr. Meyerbeck was formerly the presiding judge of the Patent Senate at the Federal Court of Justice in Germany, and now at the Antitrust Senate. He said it's a bad idea to regulate prices by the courts, and even I was told by judges a couple of years ago they've never seen a licensing agreement, even an agreement. That has probably changed, but they have no experience in licensing discussions. They have no economic background. So I have the same education as a judge in Germany, and I would probably tell you I'm not very qualified to decide what is the right rate to be paid for a certain patent, because I'm not active in this sphere. What I would therefore look more to is to provide a legal framework which makes pool licensing attractive, to encourage pool licensing by providing more guidelines, maybe, as I indicated before, the European Commission developing a practice again to issue letters of comfort, to look at pools and say, okay, you've set it up like this, and the way you set it up, that's okay for us. This is friend at the outset. I mean, later on, there might be some agreements being closed, and you can still assess whether there's discrimination or not. You can't tell that into the future. But as an outset, this rate is okay with us. We don't have concerns. Go ahead. That would really streamline a lot of the negotiation process, and a lot of litigation questions would go away, and probably also a lot of court cases would go away. There have been other ideas floated around making pools mandatory. So you set up basically, kind of what we have in Germany for copyrights, where every copywriter.
This logic.
Say again, please.
This was the logic of a collecting society.
Yeah, so you have a mandatory pool in that theory for, let's say, 3G, and every patent owner and every licensee has to join it, by law. I'm not so sure that this approach works, because what we are looking at in the licensing sphere is, first of all, worldwide licenses. So are you going to set up a worldwide pool agency to do that, which seems downright impossible to cover even the major markets as China, US, and Europe with one such agency and agree on a rate and how it's distributed? I mean, there are also legal concerns. Can you really force a company to contribute its patents to that? And if you look at this distribution of royalties for copyrights, where this is basically implemented in Germany, the system is quite dysfunctional. It disfavors smaller artists and so on. So I have a lot of reservations about that.
Yeah, I mean, Thilman, that's maybe different in the training of German and English judges. In the UK, you can basically study and do anything and become anything you want to be in life. And even judges who have studied economics or God knows what, music, or in the IP space, often some technology stuff rather than law. So, and in Germany, I was invited to the Academy for the Judges in Trier to teach them valuation and explain to them reasoning around intellectual property valuation and calculations. And it was welcome with quite an interest along such important questions. There, someone who copied, someone who makes like artificial hair. If you lost your hair, how on earth would you really assess the damage? Then what came also, especially what was the court's interest, are we assessing the court fees adequately? Because if we don't check really the value of the deal, maybe the court doesn't get enough and maybe we should charge more. That was mainly their thinking, because party A pops a number at the beginning of the case and then party B does something blah, blah. And then the court just says, okay, that's the worth of that thing. And they very critically reconsidered, if this is really the right approach to go. So there is a certain appetite in the German judiciary to look into these questions more deeply eventually, but I agree that in Germany it is the questions are always more around injunctions or not injunctions, or do you have any justification at all in terms of how you cooked up your numbers?
Yeah, and I mean
it's a different philosophy.
Yeah, that is also the same. It works in other anti-competition law cases. Why would you treat patents differently from, let's say, a train monopoly or something, where you have a few carriers who control the network, or, even mobile phone carriers, and, wherever you have market dominance, you have effectively the same questions that arise now with standard essential patents, and never you have any price fixing by the courts who will say, this price is too high and I've put the price at 80 cents or so. It's completely unheard of. And even, for the UK judges, I accept they have different backgrounds. Also, proceedings are handled differently. You have more expert opinions. You have much deeper and more detailed hearings. And I really have a lot of respect for UK case law, but I think it's a questionable approach to replace the judgment of people like John and others probably here on the webinar or in the industry who have decades of experience in discussing licensing agreements and replacing this knowledge by someone who's never done that before, and thinking that this person is now in the best position to determine what's fair and reasonable. It seems like a strange approach to me.
Mm. Coming back now to, sorry, to what I read, so what about the business then? How does that relate? How would you advise an owner of patents to make use of patent pools as a business strategy? And also, how would you advise a downstream innovator to make use of a pool as terms of an overarching business strategy? So sort of like making that linkage between our small IP community and the rest of the world, who usually wonders, what are we really doing here? And getting the senior management excited, why to bother with this? What's your take on that?
As to a business strategy for a patent owner, does the pool make sense? I think that's part of the first part of your question.
Mm-hmm.
And sure, like lawyers typically answer, it depends, but I will give you more information than that. So some patent owners don't prefer pools. They license bilaterally, either because they have the capability in-house to do it, and therefore they don't need to outsource it to an agent, or they have a different licensing strategy, such as not licensing only their one type of standard essential patents by themselves. They may bundle them together. So they might bundle their 3G, 4G, 5G patents with their video and audio codec patents and offer that as a solution to a handset maker. In those situations, joining patent pool for one particular technology doesn't make sense. But that's probably not the majority of the active patent licensing entities. Many of them do support the patent pool environment because of the efficiencies I mentioned, because of the fact that it provides a more level playing field. It unblocks some of the issues so that the technology as adopted by the market can be done faster by removing the patent issues. So if it's a company that wants to promote the technology adoption in the marketplace, joining and supporting a patent pool helps. Get the IP issues aside, get them put in a one-stop shop, and focus on commercializing the market. If you're a small entity, another type of company, yes, you may also want to commercialize the technology, but if getting a return on your investment in the patents is important, you're not going to be able to do that if you have a small portfolio. And therefore, you need to join a pool or sell your patents or outsource them to an NPE who will litigate. And that's not something, let's say, at least I would recommend. And I want to just read a quote from the US Department of Justice in approving a pool that just takes it sort of matter-of-factly that if you have a small portfolio, you're not going to be able to do much with it. And they said in approving a pool just in January of 2021, so it's relevant in timing of their perception, they said that pool participants, it's good for them because they may not have enough patents in a particular area to be of interest to potential licensees. So it's not that the technology in the patent is great or that it's pioneering, it's just, do you have enough to be of interest? If you don't have enough, it's not interesting to implementers. That's unfortunately a marketplace reality. And for those then small patent owners, pools should be part of their business strategy. So to recap, yeah, if you don't have the in-house capability, if you want to support what is perceived as a less aggressive and more industry sponsored solution, because it does, as I mentioned, bring the interests of the patent owners and the implementers together in the formation. And also because maybe you don't have enough to be out licensing it on your own, then the pools should be part of your business strategy. Okay. I will stop there.
Good. I knew we had a lot of questions and we wouldn't get this. We have a few questions also from the audience. Quite a few. Wow, these are whole essays we got from the audience, not just questions. Jesus. Okay, so let me see. Please apologize. I hope I pronounced the name rightly. Tin Sin Wang. Maybe commercialization is one of the important purposes for startups or SMEs to patent, but it is usually not a typical strategic use for established ICT firms. Yeah, so basically, I think it's more a comment really around different IP commercialization strategies in large and small companies. Do you feel come up? I don't know. Esther van Simmeren, a scholar, a Belgium scholar, she is saying there have been many reflections as to why the patent pool model has not taken off in other sectors, such as the biomedical sector. What is your position on that? Then Vincente Zafrila Diaz-Mata asked regarding the issue of having venture capitalists outside the ecosystem. Patent holders will still receive returns from the patent. The VC pay them when acquiring the patent or funding the litigation. They are only externalizing the risk of VCs eventually losing some margin in exchange of safety or an actual cash flow rather than waiting for the uncertain outcome of a judgment. Thoughts? Do you feel inspired to comment on any of these observations? Or
no, I think we should. Well, the first one you said was a comment. The second one was a question. If I can summarize it, is why haven't patent pools succeeded in the pharmaceutical space? And that's a good question because there have been some attempts, and they have not taken off the way it has in the IT or consumer electronics space. There has been a patent pool that was started back in 2017 for CRISPR, the gene editing technology. But it has sort of been put on hold because two of the largest patent holders in that space are fighting over priority rights, and they're in court at the moment fighting over that. And because of that, nobody knows who really owns those certain patents, who has priority to the inventions. And so that has delayed the formation of the pool because a critical amount of the patents are not going in. There has been also another attempt that's currently ongoing called Increscent Therapeutics, which is a platform for drug development and design. And that's underway, it's in formation. So there are efforts that are occurring out there that I'm aware of. They take some of the good principles of patent pools, try to evolve it to the market that they are targeting. And I think it's underway. It's coming. And we might even see it for COVID-19 vaccines and treatments. I mean, that would be a good solution to remove the patent issues so that the products can get out there into the market and not be stymied by hesitation or actual patent disputes.
And maybe, John, let me briefly also comment on that, because I think it's a good question. I fully agree with you that I think we might see more of that in the future, non-essential patent pools. One legal obstacle I see is that, in particular in Europe, you have currently quite a strict requirement from the EU Commission that a pool must not bundle what they call supplemental patents. So alternative technical solutions should not be in one pool because they are saying effectively, that the licensee then has a choice. If there's several patented solutions to one problem, you can go either direction. Once you put them in the pool, you are deprived of this choice and you're forming an artificial monopoly. That's their concern.
Sure, and you're eliminating the competition between the different patented methods, technology, whatever.
Yeah, right.
And you want to look at it.
And for standard essential patents, it's quite easy to avoid this problem, because you have really a 2,000 pages spec, and you can tell, okay, this patent reads on the spec, and as you said, you have this evaluation process before a patent is admitted to the pool. It's typically run through a patent attorney who confirms its essentiality. This is much more difficult if you have a non-standardized technology. For example, if you look at the CRISPR pool from MPEG-LA, they have a document on their webpage where they outline the technology, and they basically says everything that reads on this can be admitted to the pool, and this document is 2 or 3 pages long. Now, I don't have a lot of expertise in gene editing, or to say less than 0 expertise there, but it creates a lot of legal problems to really determine, can you pool these patents, or are these actually supplements? And the one pool I've been working on, one joint licensing program, was indeed for non-standard essential patents, and it's incredibly different. It was a limited number of patents, relatively small if you compare it to MPEG-LA. Let's say, I don't recall the exact number, but maybe 150 patent families. But to go through all of them and determine are they supplemental or not, you need so much exchange with the engineers and so on. It was really, really a big factor. And I would hope that this goes away when the Commission reviews its technology transfer guidelines. The US authorities have a more relaxed approach to that. They are not as strict.
Yeah, no, I think you bring up some very good things to touch on here. So earlier this year, the US Department of Justice did give its indirect approval through a business review letter for a pool set up by a group of 15 universities, well-known names, Harvard, Yale, University of California Institute of Technology, University of Michigan, Penn State, on, real top name institutes, and therefore presumably putting out some very serious technology in their R&D efforts. And this pool is exactly what you described you worked on, and contrary to what has already been approved. So it's all non-standard essential patents. And the Department of Justice still wants to keep out patents that will compete with each other, what they call substitute patents, a patent covering one way of doing something versus another way of doing, where they substitute. So the group, it's called the University Technology Licensing Program. They made a commitment to review all their patents that are being offered and to keep out substitutes. And then they will bundle what they consider to be only complementary patents, even though they are not essential, in bundles. They also, as a safeguard, they offer the licensee the ability to choose one particular bundle versus another, or within the bundles to just choose the patents that it seeks to be licensed under. So what's good is you are seeing an evolution of the patent pool model into other areas beyond the SCP for one typical technology, and now trying to help universities overcome the marketing and enforcement efforts to license what presumably is good technology. That quote that I read earlier about if you only have a few patents, licensees are not interested in them. Well, that came from that business review letter.
Well, so John and Thilman, you're not favoring the idea of patent waivers, I hear, for COVID-19. This is not what you seem to be seeing as a solution. You more see it as a pool solution.
Myself, I see it undermining the whole ecosystem of developing technology, having patents to protect that development, and getting a return on patents to fund future, past and future research. So the waivers, I think, may not be the best way to address it without having these negative consequences on the innovation system. Instead, you can provide funding to countries to help them purchase the patent, the medicines, not patents. So don't ask the patent owners to fund it. Have governments fund the distribution of vaccines and treatments.
Yeah, I agree to that. Maybe
we are over time, I think. But
okay.
Thilman, go ahead.
No, just I didn't want to let Vicente's request for thoughts to go completely unanswered. I completely agree. Yeah, and from a legal standpoint, it doesn't matter whether the patent is owned by an innovator or by an NPE. And therefore, also me personally, I wouldn't differentiate, and what you outlined there is correct. Nonetheless, obviously, if you sell patents to non-industry players, which are then often regarded as NPEs, or which are NPEs and sometimes called trolls as well, you have a certain disruption because these companies are not necessarily, let's say, playing within the customary bonds of this market. Yeah, they don't have business connections they need to take into account, and that's why these are often found to be very aggressive and disrupting the market, and some of them have indeed engaged in very questionable practices. So I think this is the underlying bad feeling behind it, but I agree with you. If you sell your patent to a VC firm or another NPE, sure, you get basically an upfront payment on the royalties.
Yeah, we touched the right area. We tried to solve the COVID crisis alongside really understanding that the biotech and the ICT space. We are over time. This was incredibly interesting and stimulating, and I learned a lot. I did not know that rates moved from $4 to 20 cents and then somewhere up again eventually in life. That was quite insightful, and I thought it was also really interesting to understand that the break or make it question is really get the rates right and make sure you have buy-in from a lot of people. It's probably a diplomacy job more than anything to run a pool. Just an outsider's impression. Yeah, no, very, very interesting. Thank you very much for taking the time, for giving us your insights from the real world, really, and for providing, thoughts which are nowhere written really down. This is always the most interesting perspective you can really generate and gather. Thank you very much for taking the time. Maybe we should throw in a disclaimer: the views expressed here are not necessarily those of OxFirst, of Philips, of Eisenfuhr and Speiser. They're personal views. Do not use it in any way. That's the best way. Thanks again very much. We hope to make this webinar soon available online. Soon is not further defined here. Hope that you'll join us for one of our next events, which we are going to host next year. Have a wonderful Christmas and all the very best for next year. Stay safe and healthy. Don't get Corona or Omicron again, also terrible diseases.
Yeah.
Thank you very, very much for joining today.
Okay.
And big thank you to Thilman and John for taking the time.
Thank you. It was a pleasure to be here, and we thank also all the audience for participating and following. And best wishes in the new year.
Yes, same from me.
Okay.
Bye-bye.
Thanks, everyone.
Thank
Okay,
you.
bye-bye.
Bye.